She's
Mom is doing great.
oh good. I haven't heard much lately.
Yeah, no, she's doing great. Of course, she and my niece, they have their own little special bond
Oh,
and their
yeah.
own special way to communicate. So whenever I come home, I learn what certain things mean.
Yeah, yeah.
And she's like, no, Stephanie, this is what she wants you to do. I'm like,
You're still on the
okay.
outside.
yeah, I'm on the outside. I'm like, get me in. And then my mom, sometimes when I'm there, she'll go to the kitchen. She's like, Stephanie, so you and her can rebond.
Oh,
And so we'll just sit on the couch together and bond together, which means that I'm letting her do whatever she wants to do.
well, I tell you what, it's funny how like they say it's not necessarily, and I truly believe this too. It's not about what you do or if you give him stuff,
Mhm.
it's about this time.
Oh, it
You know,
is.
if you've been sitting there and y'all aren't even doing it, because like with my little girl, a lot of times she just wants to, I go, what do you want to do today? And I'm thinking zoo or
Yeah.
go ride the horse or something. And she's like, relax. She wants to lay on the couch and, you know, not every day,
Oh, yeah.
but like, that's what we do sometimes. And, you know, sometimes I'm like, I need that too.
Oh, yeah.
But she just like, that's that time spent with somebody, especially little ones.
Oh, yeah. So she and I have a game we play where she chases me around the house and then she'll play hide and seek. But her idea of hide and seek is she's not really hiding, but you have to pretend like
You have to act like you can't
it's
see
a, it's a, hey, I'm just doing this for your benefit. I really don't want to play hide and seek. And so because she likes to chase me around the house where I take these little quick short
Yeah.
steps, my mom tells her, look, grandma can't do as fast as Stephanie. So,
Oh,
but it's fun.
well,
So I always can't wait to see her. Time is going by so quickly.
well, my little girl turned 11. And I can't believe it. And I remember pulling up to my mom's house
Mhm.
years ago now. And my little girl loved horses since she was a little baby. And my mom had my daughter outside and my daughter wouldn't be, she would do the lunging like a horse,
Mhm.
but she made my mom put a leash on her and she taped a little tail to her and she'd do these little things like, I'm like, and I pull up to the house and they're outside of the yard. And like my little girl, she's like just like in like little shorts or something like that. I'm like, what are y'all doing? Like what time was her diaper?
Yeah.
What are y'all doing? You have a kid on a leash.
Yeah.
And and then to this day, I'll never forget that. It cracks me up.
I
Oh,
hope you got a video.
oh yeah, I got several. That's why I just started, you know, you gotta archive them or something, you know, because it takes up so much space, but it's funny because things come up like the trailer that we're using for the horse. A year ago, we went and picked it up from the farm
Mhm.
and now like that came up on my little like history. It was like, man, it's been a year since we've been like
Oh, yeah.
going to different rodeos and stuff. So
And it's so funny because my niece, I'll show her a video. My mom said, show it to her. And we'll be like, who is that? And she's like, baby, move it out of the way. You know, and we're like, that's you. No, baby.
that's so big.
Oh, yeah.
Oh, only two. Yeah, you said revoke it, just somebody said revoke it to the right. What about the case?
Is it slow?
Why didn't you? Pick up the cases and revoke. We start away.
No, for Robert Porter.
We don't, those aren't indicted yet. We don't have to. Are you a side?
Oh, okay, we need our 50 minutes? Okay, we need our 50 minutes. Then, Francis.
Jonathan, we're just waiting for your client to zoom in.
Rick, which is who is also.
So you can check with him and I'll take you all up first.
Okay, thanks, Judge.
You're welcome.
Dennis and Medina. Rigby too? Rigby is the same as Medina.
Vashawn,
Yes, ma'am?
there is a song, isn't it? Ricky, don't lose that number.
Yes. You're showing your age.
Thank you. Oh, let me just tell you, I don't know if that's showing my age because I would always listen to all the music that my grandmother listened to and my mom listened to. It was just great music. Because I love the song Ain't No Love in the Heart of the City by Bobby Blue Bland. You play that sort of gets you into the mood for life. They played that, they put that as a part of the soundtrack on Lincoln Lawyer, the first one with Matthew McConaughey. That movie has a great soundtrack.
Maybe that's what it's He's supposed to have returned to life.
All right, when you all are ready on Jaime Escobedo, let the court know. They're not ready on that one. All right, sure. So that will be that. And then are you all ready on Randy Folsom?
Yes, Your Honor.
All right, if you all can come up. Good afternoon, Mr. Folsom.
How are you doing, Judge?
I'm doing okay. Every time I hear your name, it makes me think of Johnny Cash.
Yes, he's not with us no
No,
longer,
he's
but
not.
it's,
But I thought he was a good singer.
yeah, he has some good music.
All right, so what are we here for?
I believe, Your Honor, it's reflected as plea bargain deadline.
Yes.
Upon closer looking into the evidence, my client wanted me to see about the initial basis for the stop. Seems like there were two police vehicles, one in front of the other, and there's video dash cam on one, but not the one that's closest to making the stop.
Okay.
Upon review in advance of the discovery, there were some other files in there, I believe, associated with a different case. So that led to a little confusion. However, I have brought the issue to the state's attention, and they can give me that additional video, Judge. However, I'm gonna need something bigger than this USB. So I was gonna have court tomorrow and then get that video, but we're requesting a 2-week reset as there might be a suppressional issue that he may want me to urge based upon that video I'm gonna get tomorrow.
All right, Ms. Ferguson, I need a 2-week reset date. And it's discovery.
April 7th.
All right, we'll be back on April 7th.
Thank you, Your Honor.
You're welcome. Any questions, Mr. Folsom? All right, we'll see you back on April 7th.
Thank you, Judge.
You're welcome.
Have a seat, sir.
Anyone else ready? Okay.
I may approach, Your Honor.
Yes.
Yes, Your Honor, I have got I was given notice by the court that I have a MTR tomorrow.
Mhm.
But I have not been appointed by MAC on that because I'm off wheel.
Oh, Ms. Ferguson has already taken care of that.
Who?
Norma Ferguson.
Oh, hold
coordinator.
on. She has a last name? I didn't know that.
Yes, so if you'll talk to her,
Okay.
thank you.
Judge, he's not looking at it. This is a different case that's set for tomorrow, but he's approaching on.
No, that's what I'm saying. We've already discussed that. And it was Robert Porter, am I correct?
This was on a different, that was set
Good night. Yeah, I don't see it. Yes.
And that's the, Norma, that's the one I was always talking about, the one.
What does? There's, she's still coming up. What's that?
Right now. So much.
Yes. What do you want? I'll purchase it. Thank you. No, yeah, that's. I don't want to back.
Don't see him when he's in the yes. That's like, yeah, that's what I was like. But this, yeah. There's no, right one. Show that it's, charging instrument, it's an element of safety. So we are like. Yes. But it's also. Right, so, I think that's. I love. Never give us. But. That's too much. It goes. And the second one on top. Colors are 0012444. Move over. Yes. Yeah. You're gonna be in the middle. Like when you have somebody moved out and I don't want to sit there in the corner because I have to be. Okay, then it's not just. No. Much more respectful.
Or do you charge of data? No, you have to. Yeah.
Yeah. I'll tell you what. Hold on.
Okay.
All right, Norma. On this case, I have Victoria Villarreal. And the defense attorney is saying that a motion has been filed for competency is not listed in Odyssey.
Zero 1934.
Because Victoria Villarreal, are you saying that person needs the competence or is it Mary Stella Guerrero?
Mary Stella.
All right, so what is this issue with? It's forward, it's Victoria Castro Villarreal. Is he the attorney on that as well? Who is Victoria Castro Villarreal? Deputy Laura, could you have, or Deputy Mejia, could you have,
Downstairs, Judge.
all right, could you bring her up?
The attorney's not here, Judge.
I know. I need to speak with her.
Oh, I'm not asking. Oh, that's.
Yeah.
Last thing I have to do.
Thanks for that.
Gotcha. Thank you. If I will agree with that.
then we need an update on what's happening with this in the magistrate's court. And Norm, I need a 60-day reset on Daniel Montoya. All right, thank you. All right, and on this one, they're approaching, they're ready on it. And it's the same for this. And could I see the file on Darwin Gomez, please? I think he's on today's docket. Or maybe not. Oh, here you go. You can just put that back. It's an off docket matter. No, it's an off docket matter. All right, Mr. Caballero, if you'll call your defense attorney and have them zoom back in, he was actually on at 1:30, but you were not. So if you'll have him zoom back in and we'll take your matter up.
Okay, thank you.
And I'm so sorry, can I have the Caballero file back? It's a paper file. Thank you. Is there anyone that's ready before we take up, we're gonna do Caballero and then we're gonna take up Mr. Ashbaugh. That's my understanding, a motion to suppress.
All right, thank you. Have a motion that I need to take up circumstances that changed prior to that.
Okay, all right, thank you.
Your Honor, we have Plea ready in just very few minutes.
All right. So are you gonna continue with the motion to suppress or no?
Well, it really depends, and it's gonna require some explanation, Judge, so.
Okay,
I'll explain it when you give me a little bit of time.
okay, sure.
It really depends on the court's ruling on a couple of matters.
Okay.
Thanks.
Have you all conferred? All right, do you want to confer with the state on whatever the extra matters are? All right. Yes. I'm sorry, what?
It's an administrative issue.
Yes.
She has an FTR and state jail FTR.
Mhm.
But she also has two new number one's an ag assault.
Mhm.
It's in its early stages. The MTR, they want to revoke her. But this is one of those, I don't want this case to be sitting on my desk, his desk for a year and a half, waiting to see what the heck's going on. So I'm just asking the court what the court wants to do.
And Judge, I think it's one of those circumstances where it's an NTR.
Oh, just a second. All right, are the parties ready on Caballero? The defense counsel has zoomed in. All right, and Christopher Caballero.
Yes, ma'am.
All right, we're gonna go on the record. Court is calling 2019 CR 10379 State versus Christopher Ryan Caballero. Can I have parties announced for the record for the state?
Andrew Harris Edelman.
Defense.
And Jonathan Chavez for Mr. Caballero.
And are you Mr. Caballero?
Yes, this is Mr. Caballero.
All right, and nobody has any objections to Mr. Caballero appearing by Zoom, is that correct, State?
Correct.
And Mr. Caballero, you do understand that you can appear in court as opposed to appearing by Zoom? Do you understand?
Correct, I do.
And you have no objections to appearing by Zoom?
No, I do not.
All right, so, Mr. Chavez, you filed an amended motion for the return of seized property. My
Yes.
understanding is that we had a previous hearing on the motion for return to seized property. And the state at that time said they had no objections to return of the US currency which was in the amount of $823 and 3 cell phones. And those two items were given to the attorney, Mr. Kalfas. And you're asking the court to amend the order to state that the US currency and the 3 cell phones are to be turned over to Mr. Caballero. Is that correct?
Yes, Your Honor.
And state, do you have any objections in regards to items 17 and 18 that those be returned to Mr. Caballero? All right, so the court will order that item 17, which is $823, and item 18, which is 3 cell phones, be returned to Mr. Caballero. And how we came to be here is that the defendant was charged with possession with intent to deliver controlled substance 400 grams. And the defendant was placed in the pretrial diversion program. Is that correct?
Correct.
And he completed the pretrial diversion program. Is that correct?
Correct.
Yes.
And with that completion, his case was dismissed. Is that correct?
Not exact. His case was dismissed when he was accepted into the pretrial diversion program, who then participated in the pretrial diversion program, successfully completed it. So by the terms of the agreement, the state is barred from prosecuting him in the future for this offense.
All right. So suffices to say, his case was dismissed. Is that correct?
Yes.
All right. And the case was dismissed because of his agreed participation in a pretrial diversion program, and that was done by contract. Is that correct?
Correct.
And the persons who signed that contract were, I'm assuming, Mr. Caballero, somebody from the state, and perhaps the defense counsel. Is that correct or no? Or is the only person who signed the contract is the defendant and a state's assistant district attorney?
Mr. Caballero signed personally, and attorney for the defendant, and an attorney representing the state. I cannot tell from the signatures who the attorneys for the defendant and the state were.
All right. And as a part of the contract that was entered into, was there anything placed in the contract that the defendant was not to receive the weapons that were seized under cause number 2019 CR 10379?
No.
All right. Then the next question becomes this. According to everything that the court has read, whether or not he's entitled to his guns back depends on whether or not, one, does the entering into a contract for pretrial diversion means that there was a prosecution or there was not a prosecution? Because in Article 1819, it says if there is no prosecution or conviction for an offense involving the weapon seized. So the question is, was there a prosecution legally?
I believe so.
All right, and state, why do you think there was a prosecution?
As far as I can tell, whether or not there was a prosecution is not delineated in the case law or by statute.
Mhm.
And so from the state's perspective, if the state effectuated an arrest and then sought and received an indictment and proceeded in a court with authority over the person, that constitutes a prosecution.
All right, and defense?
Yeah, Your Honor, my understanding of the pretrial diversion agreement, after looking at it, is that it's an agreement between the state and the defense to take the case out of the court, so essentially out of litigation, and resolve it between the state and the defense without court intervention. My understanding is that a prosecution would be if we were going through the court and they're actively pursuing a conviction in the case.
All right, well, that's going to have to be something that the Fourth Court of Appeals is going to interpret, because the court has not received, or the appellate courts, I should say, because the court has not received any case law from either party to state that proceeding with a pretrial diversion means that it is not a prosecution. And I don't have any case law that says it's something different. So that will be a definition that whomever is ultimately going to decide, be it appellate court or the legislature, ultimately, they're going to have to define what a prosecution actually means. Because Article 18.19 says if there is no prosecution or conviction, and I think we all can agree that there was no conviction in this case. So the question becomes if there was a prosecution. And the fact that they're using the word "or" suggests that you have to determine whether or not there was no prosecution or conviction. And I don't have a definition for that in any of the articles that I have read. So with regards to the return of the return of item number 14, which is a loaded Springfield Armory XD 9mm handgun with 1 magazine and 12 live rounds. The court is going to deny the motion to return. With regards to item number 15, a Sega 7.69mm rifle with 1 magazine and 10 live rounds, the court is going to deny the return of the seized items. All right, is there anything else?
Nothing in the state, Judge.
Nothing from the defense, Honor.
All right, we can go off the record. Might I suggest if people don't want certain items returned to people, then that should be placed in a contract. All right. All right, thank you.
Thanks, Your Honor. May I be excused?
Yes, you may be excused.
Thanks. Have a good day.
You too.
Judge Victoria, Gabrielle is here.
All right, thank you. If she can come up, please.
No, not you, Miss Victoria.
Oh, no. All right. Your attorney is not going to be here today. If you would like, we can see about having another person appointed to you. Have you had contact with your attorney?
No, my boyfriend tried calling him. He had not returned none of my calls.
All right. And you are Miss Victoria Villarreal?
Yes, ma'am.
All right, just have a seat and we'll make sure we get an attorney for you, okay?
Thank you.
Question for you.
Yes.
For Daniel Montoya,
Mhm.
you're coming in a Saturday?
Norma gave me that court date. I mean, people are not reading the calendar. Yeah, you did. People are trying to gaslight me. That's the court date I was given. So let me go through and I'm going to give you a court date, Deputy Laura. What page is he on, Deputy Laura?
This page 2.
There's a lot I have to do. Now I'm gonna have to check all dates. All right. Put him down for May 19th.
Judge, I just don't want to go on another weekend or. a
Oh,
three-day weekend or
let's
some
not do
other
this.
Vacation time. I'm gonna wait till you have to.
The record for the state. Defense.
Brandon Lopez for Ms. Ballinger.
Oh,
Terrible.
oh. Hey, are you Miss Ballinger?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Ballinger, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive reading, Your Honor.
State, are you proceeding on the indictment as presented?
Sure, Your Honor.
Ms. Ballinger, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir. Yes, ma'am. Sorry.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up
Yes.
to a $10,000 fine.
Mhm.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent. Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do, Your Honor.
Ms. Ballinger, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine. State recommends community supervision, and there's to be restitution to SAPD for drug testing. Did you understand that? to be
Yes,
the
I
plea?
do understand.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with the attorney? Did you understand it?
Yes.
Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal?
Yes,
The
I
only
do
items
understand.
that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No such motion, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and 150 hours of community service restitution. Did you understand those are recommendations from the state?
Yes.
And the court does not have to follow those recommendations.
Yes.
Then to the offense as charged, how do you plead?
No contest.
State any evidence.
Yes, Your Honor. State exhibit number 1 with all those attachments.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements
Yes, ma'am.
and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we ask that the court follow the plea bargain.
All right, so with regards to mental health, I read in the police report that there was an emergency detention. Is there any question about her sanity at the time of the offense?
Your Honor, I don't have questions about that. I believe it's related to the charge that she was charged with.
Okay. All right, do you have a place to stay if you were released today?
Yes, ma'am, I do.
And who would you be staying with?
1300 Mark.
No. Who would you be staying with?
I've been staying at the shelter.
Okay. And have you had any type of employment?
Yes, I work self-employed. I dance and sing,
Okay,
and I make good money.
okay. All right, so where are you dancing and singing?
I dance and sing in the streets. I do it to entertain families and stuff.
Okay, so here's the thing.
Uh-huh.
You're gonna have to get employment.
I will do
not on
that.
the street, okay?
Yes, I will do that.
Do you have any children?
I have 4 children, but they're not with me, but I'm planning on going to work. I'm gonna get help through getting on probation. It's gonna help me to get my IDs straight so I can get my IDs. And then I'm gonna plan on working 2 jobs if I got to get my life together.
All right, do you have any family support here?
I got my sister and she lives in Sweetwater, Texas, so I'm thinking about getting my probation transferred to there pretty soon. Because if I go there, I know I'll stay clean.
All right, so do you want it transferred to Sweetwater, Texas?
I do want it transferred in a couple of weeks. Yes, I do.
All right, so what county is that?
Don't know, Your Honor.
Everybody gonna Google, we're gonna see.
Because if I go there, I know I'll stay clean.
All right, that's what we need you to do, stay clean.
And I'm gonna get a card. She's gonna help me. She'll help me as long as I stay clean and help with the house. She'll let me have 3 place to live. We get to live in it. We have our own bedroom.
Nolan County.
Okay. All right, the court is going to sentence you to 2 years in the state jail facility, suspended and probated for 3 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be a TAP evaluation in custody, follow results.
Okay.
There's to be 150 hours of community service restitution. I'm gonna order daily sober support meetings.
Okay,
And that's what that's what I want her to complete instead of the community service hours. So it's gonna be daily sober support meetings. So that means you need to do
I
100.
know where they're at. The one out there, when you get on, go towards San Pedro,
Mhm.
and the 24-hour meeting. I know they got them 24 hours a day, 7 days a week, and you can actually do 24 meetings in one day.
Awesome.
They got
I
them.
don't want you to do.
What I'm saying
24
is you can do 24 hours, like you can stay there and sleep. I've actually lived on the back porch there before.
All right. So there's gonna be,
He does getting clean, that's all there is to it, officer.
all right.
Get his ass-
So there's gonna be a transfer to Sweetwater,
Okay.
Texas, which is Nolan County.
Can I share something with you real quick?
Sure.
I got a husband, right? And we were married for 12 years. And 10 years ago, we went 12 years ago, we had sex twice. And when we were having sex, he was playing with his toys. And I realized he was playing like with his little guns and his toys, like cars and stuff. And that's all he was mentally slow. So I never had sex with him for 10 years, 12 years. We haven't had sex. And I tried to do something, it didn't work out. We're not going to have sex, but I'm gonna stay with him because I love him and he needs me because I found him playing with needles that he finds on the ground. He does stuff that he's not, he's like a child to me.
Okay.
So
All right.
that's why I'm excited.
All right. So it's gonna be a $2,000 fine
Okay.
probated. So that means you complete everything. You don't have to pay that. There's gonna be restitution to the SAPD for drug testing. If you think it's outrageous amount, just let the court know.
Okay.
And I'm gonna do want a MIC evaluation and custody. And probation, you can do a referral to Esperanza Court to see if she qualifies, and a referral to felony drug court. Probation, is there anything else? Yes. So here's the thing. Do you want to go to Nolan County or do you want to stay here in Bear County? If you stay here in Bear County, there are programs that can help you.
I'll stay here for a while and we'll work it out.
All right.
We'll take it as the year goes.
All right.
Because I'm not sure about getting the bus tickets. It's gonna take me a little while to establish that. And like you said, rules are rules.
Okay, so there'll be no transfer for now. And if you change your mind and you want to be transferred to Nolan County, all you have to do is let your probation officer know. Is there anything else, probation? Field visits 1 time per month until further notice.
Okay.
Anything else, probation? Anything else you need from the court to be successful?
No, I'm just very grateful to y'all because he needs me out there.
Okay.
He needs me.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I understand everything.
All right, because this is a plea bargain agreement, because I followed your plea bargain
I
agreement,
understand everything.
and because you waived your right to
Trust
appeal,
me.
you do not get, you do not have the court's permission to
I
appeal.
have mental problems and I hear voices, but I'm very smart. I
Oh.
understand.
Are you hearing voices now?
I've not heard any since Dad got put in jail, started taking my pills.
Okay, all right. And because this is a felony conviction, you're not allowed to own or possess any weapons or
I
ammunition.
understand everything you're saying. Trust
All
me,
right.
I get you.
All right, good luck to you.
Right? Okay.
Oh, okay.
Vashawn, tell probation and let me know how she's doing. And if they need a compliance hearing to make sure she stays on track, just let me know. All right, anyone else ready? All right, Nathaniel, have you had a chance to speak with the state?
Yes.
All right, you all want to tell me what the,
Here, my clients come up too, Judge.
sure.
Okay, so, if you recall, Judge, from the last setting, we were set for trial.
Mhm,
We were set for a motion to suppress evidence.
mhm.
About 20 minutes before that motion to suppress evidence, I was given some records pertaining directly to that motion to suppress evidence.
Mhm.
And after that, obviously, I was forced into a position where I needed to request more time to review those records
Mhm.
to see what that was about prior to the hearing.
Yes.
And you granted a continuance. I didn't want to have to ask for it, but I was forced to in order to
Well,
effectively
I
represent
didn't-
my client.
If I remember correctly, I stated that neither party will be charged a motion for continuance because if I remember correctly, and I like to think my mind is still a steel trap, although people have been trying to gaslight me of late. But what I remember is that the state had obtained some information and it wasn't information that they just had sitting in a file somewhere. And so it didn't seem that it was neglect on the state's part or lack of diligence on the state's part. And I know you needed more time to review. And so the court said, I'm not charging anyone with a continuance.
The only small part about that I would disagree with, Judge,
Mhm.
is that the San Antonio Police Department is part of the state
Mhm.
and they've had those records since for years, I'm not saying that this prosecutor had those records. But the San Antonio Police Department sat on those records until they were forced into this motion to suppress.
Mhm.
And at the time, and the state had also filed their own motion for a continuance based on the unavailability of a witness.
Okay.
And now, and you admonished the parties, Judge, at the last setting, there was going to be no more continuances. This was going to be set for trial at the end of March.
Yes.
Since then, in the last 10 to 20 days before trial, we have received a tremendous amount of evidence, Judge, that's been uploaded. There's been 212 jail calls, 44 new videos, body cams, dash cams, 53 new PDF documents. And of those documents, one of them is a 571-page gunshot residue detailed lab report of the opinions set forth in the previous gunshot residue lab report. There was a Brady notice for the gunshot residue in the Bexar County Crime Lab. The letter was written from the DA's office in December of 2024. There was punishment evidence that was uploaded, all of cases that have been in the state's possession since before even this alleged offense date, as they are older files. There was a new firearms testing report that was requested by the state on the same date as the last hearing. So on February 20th, there's a submission saying that the state requested further
So let me
firearms
ask you,
testing.
so I understand where this is going,
Yes.
but what are you going to be asking for?
I'm going to be asking for you to dismiss this case, Judge, based on a violation of my client's speedy trial rights. And if you let me just hash all that out. just so
Okay,
you
sure.
can consider that.
We'll go on the record.
Okay.
all right.
Oh, I thought we were.
No.
All right. I'm gonna have to say
No,
all that
I'm just
again.
trying to, yes, you're gonna have to say all of that again. All right. Court is calling 2000. Just one second. Excuse me. If you all on the back row, ask the deputy to move you down to the other end, please. All right, we're gonna go on the record. Court is calling 2023 CR 10004, State versus Tyler Ashball. Can I have parties announced for the record?
Megan Galloway for the state.
Nathaniel Navy for Mr. Ashbaugh.
And are you Mr. Ashball?
Yes, Your Honor.
All right, so we are here for a motion to suppress, but defense, there is something you wanted to address before the motion to suppress. Is that correct?
That's correct, Judge. I filed a motion to dismiss the indictment for violation of my client's Sixth Amendment right to a speedy trial.
And I'm sorry, just one moment. Let me make sure I have the motion to dismiss. All right, Yaya. Oh, I'm sorry, Jenna. I can't see around this screen. Yes. And state, do you have a copy of his motion?
I do, thank you. You want me to print another copy?
I think they're,
I can-
she says she's printing it now. Oh, that's okay, no problem. All right, so in this case, certain things were said that were off the record so that everything can be on the record. We were here previously where the state had more evidence to tender to defense counsel. The evidence that was tendered to defense counsel, the court is finding that it wasn't a lack of diligence on this prosecutor's part. So, and when I say prosecutor's part, I mean Miss Galloway. So once that evidence was received by Miss Galloway gave it to the defense. The court did not charge either party with a continuance because the court found that neither party was technically at fault or had unclean hands. So now we're here today for a motion to suppress, but the defense is asking the court to hear a motion to dismiss for failure to provide speedy trial and defendant's alternative motion to exclude evidence for violations of 3914 of the Code of Criminal Procedure. So far what I have said, does everyone agree that that is what happened previously?
Yes, Judge.
I would just like to add a little bit of context that I did, like, as we did off the
Yes.
record, Judge. At that hearing, I received that evidence approximately 20 minutes prior to that hearing.
Mhm.
That was evidence that was in the San Antonio Police Department's possession. They are still an arm of the state. They are still the state of Texas. So even though Miss Galloway did not, and I'm not in any way insinuating that she did, intentionally withhold that or negligently withhold that, the effect was still that the state of Texas did not timely produce that
And
evidence.
the court understands that, but I just wanted the record to be clear that even though the court understands that there are certain agencies that are considered technically, as far as discovery is concerned, under the umbrella of the district attorney's office, I didn't want the record to reflect that Attorney Galloway in some way had evidence in her possession and just did not turn it over. I understand, counsel, what you're saying is that the police department or someone else had this evidence, not her having it in her possession, but I understand the rules, counsel.
I understand.
Yes. So the evidence that you're saying was turned over to you, if you want to place on the record
Yes.
how long the legal agencies had that evidence, you can place that on the record.
And so that evidence for that motion to suppress hearing on February 20th, that was in the San Antonio Police Department's possession since I believe the date of the offense, which is May 22nd, 2022, because it was real-time cell site location information, cell phone tracking data that was to Mr. Ashbaugh's cell phone. And so they requested that through his cell phone provider, and they had possession of that since the date of the offense, which at this point has been almost 3 years. And at the last setting, Judge, you gave me time to review that, and you admonished the parties that there would be no further continuances and that we would be proceeding the trial at the end of this month, March. However, in the month of March and in the last 10 to 20 days, I believe, I've received a tremendous amount of new discovery. And as I stated, that was 212 jail calls.
And I'm sorry, counsel, sorry to interrupt. So, so that I can take proper notes. Now, the items that were given to you on February 20th, what were those items?
So February 20th was just the real-time cell site location data, which related to the pings of Mr. Ashbaugh's cell phone and license plate reader information.
All right. And how long are you saying that the police department had that evidence?
Since the date of the offense, May 22nd, 2022.
Judge, and I do have a response to that, but do you want me to wait until?
No, we'll just take everything one step at a time. So we'll start with that. So the real-time cell site data, defense, you're saying that the police department or the agency had access to that, we'll say, since May 22nd, 2022.
Yes.
And then you received it from the state on February 20th, 2025. All right, so let's start there. State, you want to address that one issue?
Yes, Judge. So regarding that cell site location data and the license plate information, that was tendered to Mr. Navy at the last setting. It is my understanding that although a detective with SAPD did receive it on the date of the offense, which is May 22nd of 2022, SAPD was not in possession of it because that detective was no longer employed with SAPD. And so once I learned of the existence of this record, I actually had to call up to the chief's office, and they were reporting to me that they weren't going to be able to retrieve it because that officer was no longer with SAPD. However, I told them that they needed to get with their IT department to get into the officer's drive to try to obtain it, but it was not. I went to look at the case file, it was not anywhere within the case file. And so ultimately, after conferring with the chief's office, they were able to retrieve it from the ether somewhere and provide it to me. As soon as I learned of that, I called Mr. Navy personally and let him know that they should be sending it to me. And then when I received it, I immediately gave it to him.
So you're saying that that first item with the real-time cell site data, that an officer retired or left the occupation and nobody had access to his data?
So that's my understanding, Judge, that it was not properly preserved, and so nobody had because it was not within the case file. I had called over to each respective unit to see if they had a case file for the case and if it was retained that way, and it was not. And so ultimately I ended up with the chief's IT office, and that's how they were able to get into something called the H tribe and retrieve it out of there.
Okay. All right. Any response?
Yes, Judge. When I was given those records, they initiated from an email that detective sent from a government email. So this is something that never left the possession of the state. While this detective may have retired, it was on his government email. I know when I've left a job and my old email is still there, then supervisors still get and sort through any emails that I may have received. Now, if there wasn't a proper procedure to make sure that was available, that's not my client's fault. But it was, all of this originated and maintained in the possession of the state. It didn't go anywhere else.
Okay. And then your next issue.
Okay, the next issue, Judge, is that in the month of March 2025, I've received a vast amount of evidence that has been previously undisclosed to me.
All right, so let's do this because I say take the easiest part first.
Right.
So one of that is jail calls.
Yes,
All right, so let's talk about the jail calls. And I'm assuming the jail calls, are these alleged to be your client's jail calls?
they are.
All right, so let's talk about jail calls.
Okay, so there's 212 jail calls by my count. That number may be off by a couple if I miscounted, but more or less 212 jail calls. Those jail calls are from the day he was arrested, which was also May 22nd, 2022, until I believe somewhere in June. But my client didn't bond out until July 14th of 2022. So I don't even know if these are the complete list of jail calls because they end at a certain date in June. But still, it's a vast number of jail calls that I would need to sort through. The state's provided. That means I assume, I don't know what they may intend to use off of there. If there's anything exculpatory, anything that's not good for my client, but I would need to review those.
All right, so state, with regards to the jail calls, because it appears based upon what defense counsel has stated, that his client was released from the jail in the year of 2022.
Yes, Judge. So the calls that were retained under this defendant's SID number were from his date of arrest, his date of release. That would be May 22nd of 2022 to July 13th, 2022. And these calls had not been pulled by any other prosecutor, and they were uploaded to e-discovery on March 3rd, 2025.
All right, so what I can tell you all with regards to the jail calls, I understand that sometimes when someone's in custody, if they keep making calls on a daily basis, then you're going to receive some phone calls, well, jail calls that are given to you not immediately because they're continuing to make calls. But in this instance, what the court is going to do with regards to his jail calls is that's going to be excluded.
Well, Judge, right now I'm not asking for exclusion because, and I'm hesitant to do so, because there may be things that that corroborate the defense in those jail calls, Judge. And so it's basically, and the gist of my argument is the state has placed me in a position between a bad decision and a worse decision.
Well,
Right?
this is what I can tell you. With regards to your real-time, the cell site data location, the court is not inclined to exclude that or grant a dismissal for that one item.
But Judge, if you would let me, I guess, just
Yes.
finish the train of thought with the evidence and then argue for the motion to
Sure.
dismiss. I understand, we'll respect whatever the court's ruling is on that, but I do believe that we have some pretty compelling arguments to make for you on that. If you'd let me do that rather
Yes.
than
Sure.
I guess piecemeal each piece of evidence. And so, okay, so we did the jail calls and then also 44 dash cam and or body cam videos. And obviously, I have not had time in the month of March of this year, from that time to trial to review all those.
And when were those given to you?
Those were given to me sometime, all of this evidence was given sometime between 10 and 20 days prior to trial, which is tomorrow.
Okay. All right, you continue.
Okay, and then 53 new PDF documents. And of those, I've identified that those include a 571-page gunshot residue report, punishment evidence of at least 4 cases that are older than this case itself. So 4 cases that the state has had in its possession since before May 22nd of 2022. Gunshot residue Brady notice that the DA's office has had because their letter is dated in December of 2024. New firearms testing that was requested by the state on the date of the last suppression hearing. So they requested firearms retesting on February 20th of 2025. And then a new firearms report was issued in March of 2025. So probably just a few weeks later. And so I have a new firearms report. Also have new cell site location reports, not real-time cell site location, but historical cell site location. And then case overview reports pertaining to this case. So those two items, those reports are dated 2022. Officers wrote those in 22, and those have not been available to me until this time. I submitted my request for discovery and was very thorough in all the different types of evidence that I was included in. All these are covered by that motion, as well as punishment evidence, which I requested on that date on June 6th of 2022. So that's over 1,000 days ago. I've requested all of this evidence, and much of it has been in the state's possession for years. Now, whether it's one ADA who didn't look at it or another one, that doesn't matter to my client. The effect is we were ready to go to trial on the evidence that we had at the last setting, and then it was reset. We got ready again to go to trial on the evidence we had for this setting, and then it turns out that there's a whole swath of new evidence. And I will tell you, Judge, that one thing I appreciate about this court is we have a lot of discovery compliance dates at first, and you make sure that all the discovery has been complete. And then once you ensure that that's been done, then you set it for plea deadline setting. And then after that, you give some, so after the client's had some time to determine whether he wants to accept a plea or reject a plea, then it proceeds to jury trial. I should be spending this time before the jury trial, preparing for the jury trial, not reviewing new evidence. And so it's undeniable at this point that Mr. Ashbaugh has made decisions on first-degree felonies, of which, if he goes to trial and loses, could potentially be spending the rest of his life in prison. He has made decisions now without knowing all the evidence that the state was going to use against him. And so at this point, Judge, there has been a violation of his speedy trial right, because the prejudice to him has been so great. He's been on ankle monitor since he bonded out, which was July 14th of 2022. So he's been on ankle monitor for about 2 years and 7 months. Varying degrees of full house arrest. I believe most of the first year was just completely full house arrest. Then after that, partial house arrest after he had established a good rapport with the court that there weren't any violations. He was allowed allowances to pick up and drop off his kids, obtain work, but he's missed many opportunities for employment. He hasn't been able to plan for the future with this hanging over his head. He has 2 small children that he doesn't know if, based on what happens, he can't make plans for the future, as I stated. And so the anxiety has been extreme. He's not been able to review all of these new reports before this trial, for which he was, we were going to be ready until we received new evidence. Every time that he meets with me, he has to request from his GPS officer to, if he can come have an attorney visit, and that's not always able to be done quickly. So he plans ahead on that. We have not had time to go sit through and go through this evidence, Judge. And so if I could now call my client as a witness, just to put on some testimony.
All right, do you not want the state to address what you have stated so far?
It just depends on what order you'd like to structure the hearing then, Judge.
All right, state, do you want to address the issues?
Judge, so I'm gonna go a little out of order, but regarding the new firearms report and defense counsel's motion, he states that the state never informed the defense that we were going to retest the firearm. That's a falsehood. I represented that to the court while Mr. Navy was standing here and his client was, that at the last setting, the firearms person, the person that did the initial firearms testing was no longer employed with Bexar County, and that he wouldn't be available for trial until sometime in mid-April. And so I informed the court at that time that I had submitted the firearm for retesting. That way the witness would be available. And at that time, I informed the court that it would take about a minimum of 2 weeks to receive the report back. And so that's why the court gave us a 30-day reset. Regarding the 571-page detailed lab report, that's the lab discovery litigation packet. It can be turned over until they finish the firearms retesting. So that's the reason for the delay on that. Regarding the punishment evidence, I would disagree with Mr. Navy that he hasn't seen any of it because he actually represented the defendant on 2 of those cases. So he had the discovery for those. It was not uploaded in this case. However, the state's fine if the court chooses to exclude that evidence. And then the GSR Brady notice, I would argue doesn't really apply in this case. All it does is notify defense that there are questions that are asked when a GSR kit is taken. And that defense should know that if you watch his client's interview, because the questions that are asked were recorded. And so that has been turned over. And regarding the dash cam video or the 44 new videos, I realized that I believe that discovery was not complete on March the 10th. And so I took it upon myself to go over to headquarters and have a meeting with the detective because I believe that there was evidence that was missing. When I first met or sat down with the detective, he informed me that he believed that those 44 videos did not exist. I told him that I believed different and that I had an obligation to turn them over if they did exist. So we sat together, we went through SCP's database, and none of those videos were preserved under the case number. And so we had to go and search through each officer individually and find the relevant video. And so that's why it was not initially turned over. Yes, it was within their possession this entire time. It just was not retained properly in the case file under the case number. And so to comply with 3914 and Heath, I did take an affirmative action to go over there and find that evidence that I believe existed and to turn it over. So I went over there on March 10th and it was turned over to Mr. Navy on March 11th.
All right. And then you wanted to call your client?
No, if I could actually respond to that, Judge.
Sure.
I don't recall Ms. Galloway saying that she was retesting the firearm. I know all of us here are the same people that were here. I don't recall that. I remember the reset reason being that that the individual who tested it would not be available, and that was the reason in the written motion. If she did say that, obviously I apologize, but I don't recall that being said at all. And if anybody else here did, then if you do you recall that, Judge? I don't remember that being said.
I do.
You do?
But here's the thing. This is what I want to stress to both parties. You all both are officers of the court. The court has never had any reason to doubt your candor and honesty with the court. So I do understand, as a former defense counsel, sometimes there are a lot of cases that you have, but the court does remember Attorney Calloway stating that it was
Okay.
going to be retested
Okay.
because the person would not be available.
Well, then on that issue, I do stand corrected.
Okay.
And then, however,
But I do understand the other points that
this
that
is
you're
very
bringing up.
troubling with the other points with the San Antonio Police Department. And even if Ms. Galloway is making an effort to go inquire about evidence and retrieve it, we need to take a broad look of the length of the case. There's been multiple prosecutors that have had a hand in this case, and it doesn't matter. We don't judge it from who's the latest prosecutor on the case. We judge it as a whole. And this is still evidence that's coming in 1,000 days after I've requested it.
Mhm.
And so this is not the first time this has happened either. We've had many discovery compliance dates on this case.
Yes.
So there's been many opportunities for the state, no matter which prosecutor it's been, to get me the full discovery on this case. And here we are nearly 3 years later, and I'm getting more. I can't be confident that I have everything there is on this case just because of the pattern that's gone on, Judge. One of those discovery compliance settings was because in evaluating the case to see if there was a possibility for a motion to suppress, I noticed that there was no body cam arrest videos on this case. And so the ADA at that time had to go to the San Antonio Police Department and request it. And it turns out that was never uploaded. So that was part of the delay. And that was 30 to 40 something videos, Judge. And then obviously at the last setting, the San Antonio Police Department had not turned over everything. And then now at this setting, the San Antonio Police Department hasn't turned over everything. So where does it end, Judge? This has become a pattern on this case. And at this point, and I don't know if you want to address it bit by bit. I still have arguments to make.
Oh, no. I'll hear your arguments. Do you want to call your client?
I do, Judge. Okay.
All right. Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Tyler Ashbrook.
All right, defense, you may proceed.
Thank you, Judge. Tyler, you were arrested on this case for this alleged offense on May 22nd of 2022. Is that correct?
Yes, I was.
Okay. And were you able to bond out immediately?
No, I was not.
How much time did you spend in custody before you were able to bond out?
A little over 2 months.
Okay. And when you did bond out, what was your condition of bond?
Well, no firearms and full GPS house arrest.
Okay, full GPS house arrest.
I wasn't able to get work or employment at all whatsoever.
And so have you had an ankle monitor on you continuously since that date?
Yes, I have.
Okay. And you were on full house arrest for a significant period of time, correct?
Yes.
You were not able to work?
No, I wasn't able to work.
Okay, you were stuck at home?
Yes.
Okay, you were unable to pick up and drop off your kids?
Yes, I've also been unable to find they've also did not renew my lease because of this case as well.
Okay, so you lost your lease in your apartment
Yeah.
because,
The home that I kept my daughter in.
okay. And so because of that, you were forced to move in with others?
Yes.
Okay, who else? Who did you move in with?
I moved in with my parents.
Okay. And was your GPS altered at some point to include the ability to seek work?
Yes, it was.
Okay. However, can you describe the difficulties you faced in seeking stable employment?
Yes, I tried to obtain work multiple times at multiple different places and got very far up until the point where the background check came or scheduling came, where they weren't able to work with my GPS officer and get me a schedule on time so I could send it to my GPS officer, or just flat outright didn't want me to work there because of the case.
Okay. And so you needed to submit a schedule of your work hours to your GPS officer.
Yes,
And some employers wanted you to have flexible hours, correct?
correct.
And because you were not able to have that, you lost out on certain job opportunities.
Correct.
Okay. So you understand that you're charged with 2 first-degree felonies and a third-degree felony, correct?
Yes, I do.
You understand that if you go to trial and lose, the punishment range is up to life in prison.
Yes, I do.
Okay. Is it fair to say that the anxiety since you've been on bond and arrested for almost these 3 years has been extreme?
Yes, very much so.
Okay. Have you given up making any sort of long-term plans because you don't know?
Yes,
Yeah, and if you could just wait till I finish the question. Have you given up, given up making any long-term plans because you don't know what the outcome of this case is going to be?
yes, I have.
Okay, and we've met many times to review the evidence on this case and discuss strategy, correct?
Yes,
Okay, and every time we meet, you have to get approved by your pretrial officer.
yes,
And is it fair to say he's not always available?
yes,
Okay, so we've had to reschedule numerous times because you can't get approval from your GPS officer.
yes,
Okay. And we've prepared for trial multiple times this month, correct?
yes.
Okay. But have we had a chance to sit down and go over all of this new evidence that we've discussed here?
No, not whatsoever.
Okay. That's the witness.
All right, any questions?
Yes, okay, Mr. Ashball, so while you've been under indictment and on ankle monitor, isn't it true that this court gave you permission to transport your daughter to the School of Science and Technology?
Yes,
And the court also amended the hours accordingly so that you'd be able to comply with that, right, and drop your daughter off?
yes,
Okay, and the court has even allowed you to appear at some hearings via Zoom, isn't that correct?
yes,
Okay, and so while you've been under indictment and on GPS monitor, you've become married, right?
yes,
Okay, and you also conceived a child with your wife, correct?
Objection, relevance.
All right, I'll hear the testimony. That'll be overruled.
You can answer the question.
yes,
Okay, and the court gave you permission to attend the birth of your child and stay in the hospital with your wife until she was released, correct?
Yes,
And the court gave you permission to spend Thanksgiving with your sister-in-law, isn't that correct?
yes.
Okay. And so when you say that you were unable to work, what employment were you doing before you were arrested?
Judge, I'm gonna object at this point.
Judge, it goes to the whether.
All
it
right,
goes to
the
the
objection
client.
will be overruled.
What were you doing before you got arrested?
I was working as a gas station clerk
Okay. And how long have you been doing that?
for 2 years.
Okay. And that was 3 to 4 months at the Circle K, right?
Yes,
And then before that, you're working at Murphy's.
yes,
And so why are you not working at Circle K anymore?
because I'm currently working at Taco Cabana.
Okay, so you have a job currently.
Yes,
Okay. And when you say that you have to move in with your parents, I mean, you've lived with them before and done this through your adult life, isn't that correct?
yes,
And trying to obtain work, I know you at one point were trying to become employed with a car dealership, is that correct?
yes.
Okay, and so when you say you tried many times to obtain work, can you just give me a better idea of what that looked like?
You know, that looked like multiple attempts, reaching out on Indeed, also going to multiple interviews, not being able to get past that background check process
Okay.
each and every time.
About how many interviews was that?
I would say about at least 4 or 5.
Okay. But ultimately you were able to gain employment with Taco Cabana, and that's where you're
Yes.
working right now.
Yes,
And so you've provided your schedule from Taco Cabana to GPS, is that correct?
yes, my manager is willing to work with me.
Okay,
He knows the situation.
thank you. No further question.
All right, any other questions?
Just briefly, Judge. But have you lost out on better paying opportunities?
Definitely so.
Okay. And so your lease was actually terminated because,
Yes, they told me they would no longer renew my lease at my apartment.
okay, nothing further, Judge.
All right, so I'm sorry, why are they not renewing your lease at your apartment?
And because of the case, they saw an article on the news of some
Okay.
sort, and they told me that they were not going to renew my lease.
All right. All right, any other questions?
Not from the state.
No, Judge.
All right, so what we'll hear argument
Okay.
and defense specifically, what are you requesting?
Judge, I'm requesting a dismissal of this indictment because my client's Sixth Amendment right to a speedy trial has been violated at this point. We have had many discovery compliance settings in this case in nearly nearly 2 years that it's been pending in court. And a lot of that was me requesting discovery. One instance, the state realized that there wasn't the discovery available that I was requesting, so they had to seek it out. As I stated at the last setting, the state had to seek out discovery that the San Antonio Police Department hadn't turned over. And then again, for the third time, the San Antonio Police Department has not turned over all the evidence in this case when we're here for our second jury trial setting. And we've been ready for both of those settings on the evidence that we've had at the time. And so I can't feel confident at this point that there's not more evidence that the San Antonio Police Department has. If we're getting it piecemeal like this, that doesn't give me a lot of confidence that they've turned over everything. And this case is old, Judge. It's almost 3 years old. And so we, in March of 2025, are still getting evidence from June of 2022 and beyond. Yes, I represented Tyler on 2 of those cases, but I did not represent him on all those cases. Some of those cases are older than that. One of them is a juvenile case. And one of them was another case that I did not represent him on. All his adult cases were dismissed, Judge. And we've been put in a position where he has to get ready, build his nerves up. He's made very difficult decisions to reject the state's offers, and he's done so without knowing all of the evidence against him. That is extreme prejudice, Judge. He's making decisions that are going to affect the rest of his life when he doesn't know all the evidence against him because the state has not provided it. And so what would have happened if he did accept one of those plea offers? Would we have just never been provided the rest of this discovery to review? And so the prejudice is extreme, Judge. We haven't had time to review this. I don't want to ask for a continuance. We've been preparing for trial. We've been ready on this evidence, but there's no time to review all the rest of this evidence that we've discussed, Judge. It's just too much. And so, as I said, I'm hesitant to ask for exclusion of evidence because I don't know if there might be something that might be exculpatory or might support the defense in this and any of that, Judge. And so we've been put in a position where it's almost Russian roulette, or as I said earlier, forced to pick between a bad decision and a worse decision. Since he's ready and he wanted to go to trial, do we just say, okay, let's proceed forward and go to trial on possibly incomplete evidence, not knowing what might be before him? Or do we are we forced into a position where if we did that, it might affect his ability to have effective representation of counsel because I haven't had a chance to review all the evidence? Or are we now forced to delay yet again because the San Antonio Police Department hasn't provided all its evidence and violate his right to a speedy trial, cause further anxiety, cause further delay, cause further harm to his life? Judge, and then if I'll just briefly discuss the factors that you consider in Barker. One is the length of the delay. And US v. Marion, Supreme Court case decided in 1971, that says that you can consider the length of the delay from the time of the arrest all the way to the present. And so a lot of this evidence is from 2022. We've been here he's had this case pending for almost 3 years. And the reason for the delay, a lot of this was for discovery, which in my opinion makes it even more egregious. There's every opportunity to disclose this, no matter which prosecutor it was. Previous prosecutors could have done that due diligence and tried to seek out all the evidence on the case when the time was appropriate. The time was appropriate when we were having discovery compliance settings. The time is not appropriate when we're set for trial. We should be preparing for trial, not reviewing new evidence. His assertion of the right. So he rejected the state's offer in November of 2024 and decided to proceed to trial. We acknowledge that we have not formally filed an assertion of that right, but that is not an automatic waiver according to Barker. It's just one of the factors that the court considers in its balancing test to decide if his right to a speedy trial has been violated. Barker states that the primary burden to ensure cases are brought to trial is on the state. And so if the state had done the state's job and provided us all the discovery during the discovery compliance settings, there wouldn't be a due process and a speedy trial violation in this case. And Barker also states courts should indulge every reasonable presumption against the waiver of right to speedy trial, and they should not presume acquiescence in the loss of those rights. I would argue we have not acquiesced to that at all. In fact, every time it's set for trial, we got ready for trial and we were going to be ready for trial. We didn't want more time at the last setting. I would argue that however the court notated that, the end result was I was provided discovery at the last minute and I had to review it to effectively represent my client. The result is that delay was on the state. And so Barker also states that the right to a speedy trial is a fundamental right. And so the burden is on the state to prove that he abandoned that right or relinquished that right. The state has not proven that to you today. Barker also said we reject a rule that a defendant who fails to demand a speedy trial forever waives his right. The better rule is simply that it is one factor to be considered into the inquiry. And so we've never filed a motion for continuance on the trial in this case.
All right, and what I can tell parties is in this court, Mr. Ashbaugh, we're in trial every week. Sometimes we have many cases that are set for trial, and the case that goes is the oldest one, or maybe it's the person who's been in jail the longest, okay?
Yes, Your Honor.
All right, and I'm sorry, defense, you may continue.
Thank you, Judge. And then lastly, prejudice to the defendant, which Barker states is the most serious factor, and I believe that one is the one that weighs most heavily in our favor. That's because I don't think there's any contention that the Michael Morton Act has been violated in this case. All of that evidence that's been given to me that's existed since 2022, there's no way that the court can consider that evidence has been given to me as soon as practicable. It doesn't matter if there's a new prosecutor on the case that just decides we look at the whole picture, Judge. Giving me evidence 1,000 days after I've requested it is not as soon as practicable. As I stated, he's made plea decisions with incomplete evidence. And then we haven't had time to review all of the evidence. We should be finishing up our pretrial preparation, not spending time arguing this motion and trying to review new evidence. And as Mr. Ashbaugh testified, all the losses of employment, his apartment, he's been on GPS, his freedom's been restricted in one way or another for almost the last 3 years, whether it was in custody or on ankle monitor. And I believe the only just result in this case, Judge, because it puts us in a position where we don't want to have to ask for a continuance, and we don't want to. And we don't want to ask to exclude the evidence at this point because we want to be able to review it and see what's in it before we ask for that. And the only just outcome, Judge, because the state has put him in a position where the Michael Morton Act has been violated and his right to a speedy trial has been violated. And so the only just outcome is a dismissal due to the violation of his right to speedy trial.
All right, state.
Judge, so the constitutional right of a speedy trial does not equal a dismissal of the charges, and that is citing County State 253 Southwest 3rd 273. And so I do want to address the Barker factors because Mr. Navy is saying that, and it is true, the defendant was arrested on May 22nd of 2022. Mr. Navy filed a notice of appearance, and I would ask the court to take judicial notice of the court's file regarding these dates. But Mr. Navy filed a motion of appearance on June 6th of 2022. A motion to substitute was then filed, removing Mr. Navy as lead counsel on December 20th of 2022. Mr. Navy is then hired and placed on the case again and on May 2nd of 2024. And so regarding the length of delay, I think the defendant hiring an attorney that late and it's after a year after he's been indicted, that would factor against the defendant and the length of delay. And so I think that the relevant time period that we would be looking at is beginning May 2nd of 2024 until now, which is less than a year. And so then regarding the defendant's assertion for a speedy trial, I mean, they have not asserted their right to speedy trial previously, and I would argue that Mr. Navy was not ready for trial in the previous settings. On June 5th of 2024, he filed a motion for inspection of physical evidence. On October 28th of 2024, he filed a motion to examine the scene. And so those are equaling that somebody that's not ready for trial and is still doing an investigation on case. And then we were here on February 20th of 2025, and that is when the parties made the court aware of the discovery that was turned over, and the state was ready to proceed at that time. So Mr. Navy can't have it both ways. He can't say, oh, I don't want the evidence excluded, but I don't want to ask for a continuance. And so at that time, he was joining in on the request for more time to review that evidence. And so the defendant's failure to make a timely demand for a speedy trial indicates that he doesn't want one, and furthermore, filing for dismissal instead of asking for a speedy trial should weaken the speedy trial claim, because it shows that they don't actually have a desire to have a speedy trial, but just want the case dismissed, and not citing Cantu and Barker. Regarding prejudice to the defendant, I haven't heard any testimony that this is emotional distress more than just what every criminal defendant has as they're awaiting trial. And so I don't believe that there was evidence that he's suffered any serious prejudice that's out of the ordinary. And so the court heard the testimony. He's been allowed to do many things while he was on ankle monitor. He has a job currently, and so we would ask that you deny the motion.
May I respond? Judge?
Yes.
I would just take issue with the point that was made that I was substituted out and then substituted back in. The state's responsibility on discovery is not to Nathaniel Navy. The state's responsibility is to Tyler Ashbaugh. And so it doesn't matter if at one point I wasn't the attorney on this case, Judge. The state has a duty to timely disclose this evidence to the defense, not any one attorney. And with regard to those settings that where I was asking to inspect the scene, asking to inspect physical evidence, these were very specific motions where there were very specific things that could not just be uploaded and I actually had to physically go do. But these were still discovery compliance settings where the state had more time. So going over all these discovery compliance settings, I think that just makes it more prejudicial and that the state was given every opportunity and every chance over years to provide me complete discovery, and it still hasn't happened. And to say that another thing, which is to say we don't really want a jury trial. Well, I don't really know how to respond to that because we rejected the offer and to this court said that we wanted a jury trial. But the question on a motion to dismiss for lack of speedy trial is not, the remedy is not to just say, okay, here's a trial. The question is whether a violation has occurred. And if a violation has occurred, the court must dismiss the case. And so the question you're deciding, Judge, is not, okay, well, when can I give you a speedy trial? It's has a violation of his right to speedy trial been violated? And I would say it has, and that the only remedy is to dismiss the case at this point. And at this point, Judge, if I could turn it over to my co-counsel for a couple points.
Yes,
Sure.
William Salazar for Mr. Ashbaugh. Your Honor, respectfully, quoting Shaw v. State in general, delay approaching 1 year is sufficient to trigger a Barker inquiry. Here we have a delay of almost 3 years that should be enough to trigger that analysis. Upon triggering Barker.
And I'm sorry, and you're saying that as it relates to his not being in jury trial?
Him not having a jury trial that affords him also the rights of due process, which includes a right to a fair trial and the right to an adequate defense.
All right, because normally this court is in trial every single week. And the cases that tend to be first are usually people who are in custody or people who have cases that are older than, cases that are older than Mr. Ashbaugh's case. So this court has been in trial on a weekly basis.
Certainly, and the defense is not positioning to the court that it's the court's trial docket that has caused this delay. The delay is resulting from getting evidence that was in the state's possession, admittedly by the state, that was not turned over until a month before trial, less than a month before trial. And in order for Mr. Ashbaugh to have an adequate, fair trial, he has to have the time to review that, and his counsel has to have the time to review that. He was deprived of that by getting relevant evidence disclosed to him only a few days before trial. Now in this defense here, Mr. Navy is in a position where he has the option to ask for exclusion of evidence that might be exculpatory, or ask for a continuance. And either one of those deprives Mr. Ashbaugh of a right to a speedy trial, which Mr. Navy and Mr. Ashbaugh were in this position not through any action of our own, but through the state's negligence and not handing over evidence that they were required to do under Heath and under Brady. And Heath has set out that the state is the state is the state, regardless if it's the DA or if it's the officers. And by triggering the Barker analysis, it's the burden shifts to the state to justify the reason for the delay. And once the court has gone into that process, it is required to weigh all four of the elements of Barker.
Okay, all right.
And if I could,
No, I'm
a
sorry.
little further, I'm sorry.
I thought you had stopped. No problem.
The constitutional right to a speedy trial is fundamental, and the Criminal Court of Appeals has talked about three key interests. Now, the state has talked about Mr. Ashbaugh's anxiety being not all that much. However, the court says that the third factor in restricting the possibility of impairment to the defense the Supreme Court, the US Supreme Court, as well as the Texas Criminal Court of Appeals has conceded that the third interest is given the most weight due to its effect on the integrity of the criminal justice system as a whole. And that's quoting Barker v. Wingo. So here we have Mr. Ashball, who has essentially been handed over evidence, a voluminous amount of evidence, just a few days before trial, and is expected to either make the decision to exclude said evidence or to proceed or continue. And neither one of those options allows, all of those options deprive Mr. Ashball of his right to a speedy trial, because he has not been afforded due process, and due process requires that he have all of the evidence as soon as practicable so that him and his counsel can form a valid defense of his case. And so now that the court has allowed the state to try to justify the delay, it's up to the court to decide if that delay is justified, if that is something they believe is justified. If an officer leaves his post and doesn't hand over evidence, and that's lost in the ether, as the state said, does Mr. Ashball have to suffer? His right to a speedy trial is a constitutional right. And because of that, all four factors have to be weighed, because a fundamental right is at stake. And if he goes forward without all the facts, without having had time to review, then he is deprived of his right to a fair trial, and he is deprived due process at that point.
Oh, is there anything else?
Your Honor, I would just say that my last thing would be that the more serious the deprivation, the more likely a defendant is to complain of the speedy trial. And that is quoted from Barker. And here we are, we haven't complained of a speedy trial up until this point because there has not been reason to complain of it until now. But it is so egregious that we have no choice but to assert that right, to remind the state of its obligation that's set out in Heath and Brady to comply with discovery. And essentially the state could, not to say they deliberately did this, but potentially in the future, they could choose to disclose important evidence the eve of trial that could be exculpatory. And essentially the defense, if they don't have time to review it, is forced the decision to exclude.
Okay, so let me just explain to everybody. I'm just dealing with this specific case, not what may happen in the future. Just
Certainly.
what's happening here.
Certainly. And that is exactly what's happened here. That is what we're facing here, is the choice.
All right, so this is what the court is going to do. Number one, I am not going to grant the motion to dismiss for want of speedy trial. Number two, with regards to exclusion of evidence, if there is any exclusion of evidence based upon what the court heard, what will be excluded will be the jail calls and any punishment evidence. But the court is not excluding that at this point because defense, you're saying you don't know if you want it excluded or not. So defense, if after reviewing everything, you decide you want the jail calls excluded, then the jail calls will be excluded. After reviewing everything, if you decide that you want the punishment evidence that was, and when I say punishment evidence state, I mean that was recently turned over. If you decide that you want that excluded, then it will be excluded. And when I say punishment evidence, the court will need more knowledge to make a determination of what punishment evidence, if there was turned over and when it was turned over. Now, next thing, with regards to the GPS, is he on tracking with curfew or no?
No, I think he's on partial house arrest. Is that right, Tyler? Yes.
All right. So I think I do not understand why pretrial services will not let him be at your office whenever you want him at your office. That is something that obviously I am extremely concerned about. I think attorneys should be allowed to meet with their clients whenever. As I said, you all are officers of the court. If you're saying that he is at your office or on the way to your office and you all want to have a meeting, if that meeting wants to be for 10 hours, you're an officer of the court. If you say the meeting was 10 hours, it was 10 hours. So I don't understand pretrial services not doing that. So with regards to GPS, what I'm going to do with GPS, he has, I think, an exclusion zone. Does he? Do you have an exclusion zone where there's a specific place you are not allowed?
No, not that I know of, Your Honor.
All right, so if there's an exclusion zone, the exclusion zone will continue. But what I will do is I will do tracking with a curfew. And that should be able to eliminate pretrial services. So you all step back and agree on a tracking with curfew and what time that will be. And with regards to the jury trial, that is tomorrow. Counsel, what I can tell you is we have other trials that are scheduled. What I want you to do, counsel, is estimate how long you think it will take you to go through whatever documents that have been given to you. And then both you and the state confer on a jury trial date that all parties can agree upon. And if there is more evidence that is turned over the defense, then the court will reconsider your motion.
Mr. Judge.
All right, is there any?
I just want it to be said, I did comply with 3914 and I did seek out the evidence myself and took it upon myself. So, he's arguing regarding the SAPD, but I did my duty as the ABA on this case to
All
comply
right.
with 3914 and B.
All right, and so the record is clear. Again, both the state and the defense, I view you all as officers of the court. And no evidence that has been presented to the court where the court believes that Attorney Galloway did not follow through on her duties and diligently seek out evidence to give to the defense. And I understand what the defense is saying about when you believe the evidence should have been given to you. But there are certain things that I understand that parties don't have any control over. I understand what the law is. I understand that the law considers the police department an arm of the state. And if the police department has it, the state constructively has it as well. So the record is closed. So if you all will confer on those two things, tracking curfew, and also when you anticipate you will be able to review what you need to review. And so it will be set on the jury trial date, which you all agree on, and a date before the actual jury trial date, so there can be a determination of whether or not you're seeking to exclude the jail calls and exclude the punishment evidence. And if there's an exclusion, you're determining that you want to exclude the punishment evidence, then we'll need to have a hearing in case the state wants to argue that maybe you received the punishment evidence beforehand. But with regards to the jail calls, if you want to exclude the jail calls, then we don't need to have a hearing on that because the court is saying the jail calls, that's something that you most definitely should have had.
And the only other question that I have, Judge, is what is the court's ruling as far as all of the other evidence that was turned over in March? Is it the same thing that applies to that?
Well,
It's
see, I
excluded until I review it.
I don't know. With that, you're not asking for it to be excluded, but you're not asking for a continuance. So with those, the only items that I am willing to exclude, because it seems that that is something that the state should have specifically been able to anticipate or have, is the jail calls. Because everybody knows the defendant is at the jail, they make phone calls. The punishment evidence, because the punishment evidence, the state should know what the punishment evidence is. If there are prior cases, then they should know that. So the other things that you mentioned, which is with the things that were in the ether, as people say, and IT had to be involved to get that, the court is not inclined to exclude that.
And Judge, my only other argument would be that that same logic should apply to the other evidence, including the firearm testing, the cell site location, and any of these other reports that were also provided, because many of these reports are from 2020.
Well, I will say with regards to the firearm testing, I do know that it was stated that that was going to be retested. And I understand that everybody gets involved in different things, but I do know that with regards to firearm testing, that was stated that that was going to be retested. I don't know if a motion was filed, but I know that that was stated.
And that report was turned over to defense on February 28th of 2025. So they've had it in advance of trial.
All right, so if you all will step over there.
Okay.
Figure out the curfew with tracking. And then also when you all would request a jury trial.
And then I'm sorry to keep having questions, Judge, but so
Yes.
regarding all the videos too, all the different dash cam and body cam videos that obviously I haven't had time to go over.
Good job.
Is that also excluded?
At this point, I will agree to everything except the cell site data and the firearms because they've had that since the last setting. The court can exclude all of that. The state's ready to go to trial tomorrow.
Okay.
So
Well, I would request, because one of those is an animation of cell site data that I just recently
and
received,
it's
so I would
data
request
that
that.
he's received. It's just like a PowerPoint presentation. So
All right.
he's got the data.
So this is what we're gonna do. The court is closing the record. Everybody has heard my ruling. It is not gonna change. So if you all will confer on a jury trial date and also confer on tracking with curfew.
Judge, and then one last thing, because of the motion to suppress and set today, we still want to go forward because the witnesses have been there since.
Well, the question becomes whether or not defense wants to go forward on the motion to suppress. If the defense is not prepared to go forward on a motion to suppress based upon what they've received, then it's gonna be reset.
I would request that it be reset to either like we did this time, Judge, either the day or the week before trial.
All right, so if y'all will confer on that and then come back to the court.
Thank
You're welcome. All right, Abel Hernandez. Okay. Jaime Escobedo. Yes.
My client actually just got out of lifetime
Yes.
recovery. He's waiting for pretrial to pick him up today and take him to sober living.
Yes,
We're working
I'm
with the
aware.
prosecutor on trying to piece a plea deal together. What I'd like to do, if your court would indulge us, is to allow us to reset 30 days to give him some time at the sober living. We are going to reach or enter a plea agreement. I would just like to give my client opportunity to experience some time at the sober living facility.
All right, and let me ask both parties this theft of property, is there restitution involved? Because I require that if there is restitution, depending on the amount, there needs to be restitution.
According to the police reports, Judge, the items which he was caught with were actually returned back to the stores.
All right. Then, Ms. Ferguson, I need a 30-day reset for plea deadline date on Mr. Escobedo. All right, April 24th will be your plea deadline date.
Yes, ma'am.
All right, thank you so much for showing up, but make sure you're on time next time, okay? All right, how's everything going with treatment?
Good.
All right, keep up the good work. All right, thank you.
Thank you, Your Honor.
You're welcome. All right, Abel Hernandez. All right, on this case, are there CPS records?
Not that I'm aware of that would directly impact the defendant.
And Your Honor, if you'll give me just one moment.
Sure.
It does look like we've requested them. I do not see them in the file. So I'm not sure that we have them. Let me just continue to look through.
All right, but you do believe that some are in existence?
I do have a request here, a note that we made a request, Your Honor. So my assumption would be yes.
All right, Ms. Ferguson, I need a 45-day reset for discovery. All right, May 8th, we'll come back and make sure that if there is some CPS records, that your counsel will have access to that. Do you have any questions?
No, Your Honor.
All right, thank you.
Thank you, my Bixby.
Yes,
Thank you, Judge.
you're welcome. All right, who's here on Jorge De Leon? Court is calling 2024 CR 012444 State versus Jorge De Leon. Who the parties announce?
Rick Manning for the state of Texas.
Defense?
Kimberly Bush on behalf of the defendant, and we are present and ready, Your Honor.
And are you Mr. De Leon?
Yes, ma'am, I am.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery probation. This is an application. Mr. De Leon, did you review the application entitled Deferred Adjudication with your attorney? Did you understand it?
Yes, ma'am, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
We waive it, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Mr. De Leon, did you review the court admonishments with your attorney? Did you understand it?
Yes, ma'am, I did.
And did you sign it in all the appropriate places?
Yes, ma'am, I did.
You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I do.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am, I do.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am, I did.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine.
Yes, ma'am, I do.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. De Leon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am, no.
Anyone promised you anything other than the plea?
No, ma'am, nobody did.
Are you satisfied with the way you've been represented?
Yes, ma'am, I do.
Are you a U.S. citizen?
Yes, ma'am, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, ma'am, I did.
Did you understand that?
Yes, ma'am.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine probated. The state is silent on your application for deferred adjudication. There's an affirmative finding of family violence and no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any
Yes.
weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Right. Yes, ma'am.
And also as a part of the agreement, there's an affirmative finding of deadly weapon. Did you understand that to be the entirety of your plea?
Yes, ma'am.
Defense, is that the plea?
That is the plea, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal?
Yes, ma'am, I
The
did.
only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, I did.
Counsel, have any such motions?
There's actually been one that was filed today, which may become moot in a moment. It's a motion to reduce bond, but that's nothing that would immediately impinge upon this plea.
All right, then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state offers into evidence State Exhibit 1 with all attachments.
No objections, Your Honor.
And state, have you spoken to the complainant?
We've attempted.
All right, state, you may be excused.
Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am, I do.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am, I do.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits one and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. All right, we can go off the record. Counsel, if you wish to have a full PSI done, it's going to be about 8 weeks. Or if you want, I can recall it. You can call whatever witnesses you want to call, and I can recall it in, at a time that's agreeable to you and your client.
I would prefer to do an abbreviated setting on it. My client has been in jail 6.5 months, which is far longer than he can afford. This case has already cost him his home, his truck.
Okay,
most of
so
his
you want it
tools.
short?
Yes.
All
I
right, so
it
you just want to
short.
call witnesses?
Just want to call witnesses. Now, there are 2 other options as I understand it. He does have a bond set in this case. I filed a motion to reduce the bond.
All right, so let's just address this first. Do you want a full PSI? Yes or no?
No,
All right. Do you want this call back on Thursday for your witnesses, or do you want it?
I can't do Thursday. I have 3 other hearings that day.
All right, so you want to call it next week?
Yes, ma'am.
All right, Ms. Ferguson, what day next week can we set this?
May I go grab my calendar?
Sure.
Yeah.
All right, you can have a seat, sir.
Thank you, man.
You're welcome. And where's the case on Salazar? Oh, here we go. That will be next. All right, what date, counsel?
Trying to get there. The 31st is fine, Your Honor, if that's all right with you.
Yes.
Okay.
All right, we'll come back on March 31st.
All right.
All right, thank you.
So, would you like to consider the motion to reduce bond?
No. I mean, if you want to have a hearing on it, we can, but I have other cases that are before yours. If you would like to wait a few moments. Sammy Salazar. Sammy Salazar. All right, Mr. Salazar, have a seat. Tony Medellin. The court is calling 2024 CR 010540 State versus Tony Salinas Medellin. Can I have parties announced?
Andrew Harris Salem for the state.
Robert Ramirez from Mr. Medellin.
And are you Mr. Medellin? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Mr. Medellin, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Court will find that the state is in compliance with discovery. Mr. Medellin, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Medellin, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of a controlled substance penalty group 1, 4,200 grams as a 2nd-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Sure.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Medellin, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, the meeting such motions.
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 6 years. There be a TAP evaluation, 200 hours of community service restitution, and no operation of a motor vehicle without production of a valid driver's license.
Yes,
Do you
Your Honor.
understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Conscience, Your Honor.
State any evidence.
Same in Exhibit 1 and attachments, Judge.
No objection.
State you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. We ask that the court follow the agreement and the recommendations. My client has a job and he has an ability to get back on his feet and do further work.
All right, do you have any children?
Yes, ma'am. I have 4.
What are their ages?
16, 9, 3, and 6.
And do they stay with you?
They stay with their mothers.
All right, so why are you riding around smoking marijuana in a vehicle?
I gotta lie to you, ma'am. I was going to see a friend and the friend was smoking before. I just so happened to have other things in the vehicle at the time, so.
All right. And for employment?
I work for HEB, for a third-party company that works for HEB. We do other construction.
All right. This is what the court is going to do. 6 years deferred adjudication, TAP evaluation, and felony drug court referral in custody follow recommendations. Regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release, no employment as a home health care provider or with minors, 200 hours of community service restitution. I'm going to order parenting classes. Once you complete parenting classes, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. There is to be no operation of a motor vehicle without a valid driver's license presented to probation. Probation, is there anything else? All right, and I'll do 90 sober support meetings in 90 days. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. You understand?
Yes, ma'am.
All right, is there anything else that you need from the court so that you can be successful? All right, good luck to you.
Thank you,
Your
ma'am.
Honor,
You're welcome.
is there a way to request an expedited TAP evaluation since you're ordering it to be done in custody?
I can say expedited, but I will tell you what's going to end up happening. It's not going to be done for 2 weeks, but I will say expedited TAP evaluation, but the problem is they are running behind schedule. I can tell you that felony drug court, they'll probably be able to see him this week.
And if that happens, would he be able to be released pending the TAP evaluation?
If, be honest with felony drug court, and they will probably accept you. And when they accept you, then they will set your conditions for probation. You understand? All right, good luck to you. You're welcome. Francis Medina.
Ready, Your Honor.
Court is calling 2024 CR 008948W. State of Texas versus Francie Garza Medina or Rigby. Could I have parties announced?
Lisa Gary here for the state, Your Honor.
Rigby?
Yes.
All right.
Robert Ford from Miss Rigby.
And are you Francis Rigby?
Yes, ma'am.
All right. And did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and State's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney? Did you understand it?
Yes.
Are you the same Francis Garces Medina Rigby, who was placed on deferred adjudication in 2024 CR 008948W
Yes, ma'am.
for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on August 29, 2024, for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violated condition number 1 on or about the 28th day of January 2025 in Bear County, Texas. The defendant Francis Garza Medina committed the offense of possession of a controlled substance in violation of condition number 1.
How do you plead to that? True or not true?
Sure.
Your Honor, will waive the remaining violated conditions.
No objection.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Sure.
I mean, did you understand that?
Yes, yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Court will find violation of condition number 1 true. Is there a proposed agreement?
No, Your Honor.
All right, state, what are you requesting?
The state is requesting revocation, Your Honor, and the state will take into consideration the possession charge. I'm just going to confirm the offense number before I put that on the record, Judge.
All right, in defense, what are you requesting?
Judge, we're requesting that you continue on her. I know before the court, the probation gave a alternate DDRF. We're making it. We agree with that. Also, Judge, if y'all we take into consideration what you just pled to again, Judge, inpatient treatment for drugs. At the end of the day, it's about drugs. She needs drug help.
All right, so here's my question. What has she done since she's been on probation?
She was in the Esperanza court. Didn't quite finish that.
All right, so why didn't she finish the Esperanza court?
I was scared to be there, ma'am. I wanted to go home. It was my mistake by doing that. But I would like to get another opportunity
Okay,
because I really need help on drugs.
all right. The court is going to grant the motion, find you guilty and revoke. What time are you all requesting? State?
Judge, we would be requesting 1 year in the state jail facility.
We're asking for the minimum, Judge.
All right. The court is going to sentence you to 1 year in the state jail facility. Give you credit for any time served. And was there any inpatient treatment that was completed?
Not that I'm aware.
All right, if there was successful inpatient treatment completed, then the court will give a credit for time in inpatient treatment. And the court is going to take in consideration 2025 PF 03556.
Your Honor, I have a question. That's been a whole year. Am I gonna be at the jail annex or?
You'll have to speak to your attorney about that. It
Okay,
depends on
I
if
don't
you
know.
have a
Okay.
case holding you.
Okay.
And I'm gonna recommend the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your
Okay.
attorney?
There were none.
Did you review this document entitled Trial Court Certification?
Yes.
All right. And did you sign it?
Yes.
All right. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition.
Yes,
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you, okay? You're welcome. All right, Tyler Ashball. Oh, and I'm sorry, that goes with that. Oh. All right, I'm sorry. Yes. On Ashball, so with regards to curfew, let's start with that. So it's gonna be partial, I'm sorry, tracking curfew. No, we're fine. So what time?
We said 11 p.m., Judge. That's because his Taco Cabana work gets out at 10 p.m. Sometimes it's midnight, but we conceded with the middle ground and he'll work till 10 p.m.
Okay, so then we're going to do, and you all will need to write in order because of the way the system. Thank you. You know, at some point you could just print a page and write it on there, no more. Yes.
Is she coming back tomorrow, Judge? Because I need to know.
Okay, just give me 1 second, just 1 second. So on this case, tracking curfew, 11 p.m. And when have you all agreed on a jury trial date?
Well, we had, but then I just remembered our investigator is moving. And
Okay.
so I'm trying to make sure that this date, moving out of the state, so trying to make sure that this date works for him.
All right, this is what we're gonna do. Your client can appear by Zoom. We're gonna recall this. How much time do you need for your investigator?
Well, I'm literally texting him right now.
Okay, then if you all will remain and let me know.
Okay.
All right, thank you. Salazar.
Good afternoon, Your Honor.
Good afternoon. Norma.
28.
That's right.
No, I'm not asking about that. With regards to Villarreal. And on Sammy Salazar, what's happening?
So far, no report, Your Honor.
All right, no report of what?
Competency.
Oh, okay. All right, Norma, do you know when they are doing the competency on Mr. Salazar? All right, so then what we'll do is, Ms. Ferguson, let's recall this May. Are we able to put this on May 27th? All right, we'll come back on May 27th. And counsel, if you wanted him brought back sooner, just let the court know.
I'll do that, Your Honor. Thank you very much.
All right, thank you.
Just the 27th.
Yes.
The 27th. May 27th. Thank you. Thank you. Thank you, Ditch.
Here, right.
I'm just trying to get everything ready for tomorrow.
Oh, no, I think we may be able to take care of that.
We have two people out of county that are gonna make it tonight. Or Docket tomorrow.
All right, who's here on Teresa Frias?
Present, Your Honor.
Hello, so why was she late for court?
Apparently, Judge, she had every intention of coming this morning. She got last minute notification that her daughter's probation officer wanted to meet with her in regard to her daughter's probation. So she was thinking that they were gonna be able to hash that out quickly and then her come.
All right, so do you have proof or did you contact anybody, counsel, that she was with the daughter's probation?
I just recently got notified, Judge, that she came up of her own will to the court. I do not have no documentation of that, Judge. And I believe in reference it to Mrs. Frias, if the court's looking at some of the history, why her probation was forfeited before was because she was the victim of a gunshot wound while she was on bond. She didn't make that, and that's why a PR bond, I believe, was subsequently granted for that reason. It's my understanding Ms. Frias was trying to get a hold of me today. However, I was here in court, so she couldn't reach me, Judge. But
State, what are you requesting? Do you want to recall the judge's warrant?
Yes, Judge.
when we're working to resolve this, please refer to a plea with regard to her case, so we can resolve her case quickly.
All right, so the court is going to recall the judge's warrant in each case. And reinstate the PR bond. And then this is going to be recalled for Norma. Are we able to set this for a plea deadline date? The first full week of April. So that'll be week of April 7th. All right, what day, counsel?
April 7th will work with defense, Your Honor.
All right, we're going to come back on April 7th. That's your plea deadline date.
Very well, Your Honor. Thank you so much.
Thank you. You're welcome. Lorenzo Garcia the fourth. Thank you. Court is calling 2024 CR 012953, State versus Lorenzo Garcia the fourth. Could I have parties announced for the record for the state?
Get your hair, Salem.
Defense?
David McLean for the defense.
All right, and are you Mr. Garcia?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Sir, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Probation, this is an application. Did you understand you're charged with driving while intoxicated, third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes,
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. State recommends community supervision, and there's a 2-year license suspension. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours community service restitution, and the ignition interlock. Did you understand those were recommendations from this state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Should be contained in Exhibit 1 and attachments, Judge.
Your Honor, I've reviewed that with my client. We have no objection.
All right, state your excuse.
Thank you, Judge.
Did you review the document entitled waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client has been attending AA on a regular basis. We came back in here because we had a compliance issue with his ignition interlock a few weeks back. There was an issue with him having some mouthwash. Court admonished him, and he has gotten the message loud and clear. He's been going to AA every day since. He intends to keep on doing that. He's addressing this problem, and he is confident that he can be successful on probation, Judge.
All right. So do you have any children?
No, ma'am.
All right. Are you employed?
Yes, ma'am.
What do you do?
I work at a bond and tissue bank.
Okay. And what do you do there?
I work for sterilization for the processors. For the, how to explain?
Okay, no
deal with
problem.
donors.
All right.
Kind of hard.
All right, this is what the court is going to do. The court is going to sentence you to 6 years in the prison, suspended and probated for 6 years. There's a $2,000 fine that will be probated. There's a 2-year license suspension. Proof of employment within 30 days. No employment as a home health care provider or with minors. TAP evaluation out of custody. Follow TAP recommendation. If TAP recommends inpatient treatment, we'll start with outpatient treatment. I want you to continue with daily AA-NA meetings. You understand?
Yes, Your Honor.
So there's to be daily sober support meetings. Has that been helping you?
Yes, ma'am.
Okay. Ignition interlock. State, are you requesting ignition interlock for half the term or until further notice?
Judge, that was not discussed, but the state would be requested until further notice.
All right, so there's going to be ignition interlock until further notice. If you wish to have ignition interlock removed, do not come to the court until the term of probation has at least expired, okay? Thank you, State. There's 200 hours of community service restitution. Since I'm requiring daily sober meetings, that'll take care of the 200 hours community service restitution. You understand?
Thank you.
So that means you're gonna have to do at least 200. You understand?
Yes, Your Honor.
There is to be the VIP Live DWI education course. Field visits 1 time per month for 3 months. Probation, is there anything else that I'm missing? Thank you. The most important thing, regular reporting by Zoom or in person and regular random UAs, and make sure there's testing for alcohol. Sir, is there anything else you need from the court to be successful?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. We can go off the record. You know you can kill people when you're driving intoxicated. I have yet to meet anyone that I have represented or that have been in the court before where they've killed someone or injured somebody from driving intoxicated who've said, oh yeah, that was my intent to get drunk and kill somebody. It happens because you're impaired. Don't be that person. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
Thank you.
Thank you, Judge. Oh, Judge, one thing with the 10 days.
Oh, excuse me, sir. That is, I was wondering, we're
Yeah.
back on the record.
I thought about it while we were
No,
talking
no,
about
no.
it, and I forgot.
All right, in lieu of 10 days in the Bear County Jail, what I'm going to do is I'm going to require that he is on GPS for 20 days. It'll be partial for employment, and I'll ask that the fees be waived.
Thank you very much, Judge.
You're welcome.
Thank you, Your Honor.
You're welcome.
Functions?
Yes.
Um,
Do y'all have a date?
yes, we do, Judge.
Okay. Oh, what's the date?
If it pleases the court, it would be.
Oh, it pleases the court.
Pretrial motions, June 9th, trial, June 10th.
Okay. Yes, it pleases the court. Does that please everyone else?
I understand it is, Judge.
Okay. All right, those are the dates. Once you get the reset form, you're excused. You're welcome. Richard Vance. Yes. Are y'all ready on Vance or no?
Can we do him last?
I'll just- yeah. Yes. Oh, is that blocked? I'm on robots. All right, who's the family here for Mary Guerrero?
She's here.
Are you Mary Guerrero? Come forward, please. Hello, Miss Guerrero. Hi. Just let me look at something very quickly, okay? How are you doing today?
My daughter was outside, but she couldn't come in because of it.
Yes, tell her to make sure next time,
To address.
yeah,
Oh.
she's not allowed to wear that in court. All right, Norma, on Mary Guerrero, what is the status on the evaluation in magistrate's court? Let me ask you, have you seen the doctor yet?
I haven't seen a doctor yet.
Okay.
I was waiting for the possible office.
Mhm. All right, so they have you scheduled for April 3rd. All right, so what we're gonna do, you're scheduled for April 3rd, so we are gonna reschedule you here. Norma, let's reschedule her here for May 5th. All right, so she's gonna give you a reset form. That April 3rd date is for a different court. It's not this court, okay? But she's gonna give you a reset form, and your attorney is not present today. He had another matter.
Thank you.
All right, thank you. Don't leave the courtroom until you get the reset form. Okay, thank you.
No, yeah.
All right, Victoria Villarreal. And counsel, I know you were just placed on this case.
Oh, yes, Judge, not a problem. And I went over the timeline with my client and told her about the 10 days. So I'll be respectfully requesting that of the court. If the court perhaps something in the realm of maybe like 3 weeks.
Okay.
I can meet with
And
her.
when are you next in this court?
Tomorrow, I'll be here.
Oh, well, we won't do you tomorrow.
I was gonna suggest, Your Honor, let me see. Are you guys available I'll be here April 15th. That works for the court.
All right, Miss Ferguson, April 15th. Is that a good time? It's on Victoria Villarreal. All right, so we're gonna recall this April 15th. And Miss Villarreal, the reason why you were given another attorney is because you said you have not had any contact with your previous attorney. Is that correct? All right, so this is going to be your attorney, and we're going to bring you back on April 15th.
Okay.
All right, thank you.
Thank you.
Thank you, counsel. All right, who do we have left on the docket? All right, if you will hand those to me. No, April 15th.
Oscar Jimenez and Richard Vance in the bottom.
All right. Here we go. All right. Josephine Marquin. Let me see what page that is. Josephine Marquin. All right, so that'll be tomorrow. Correct?
It was after four judge, so she may or may not make it, but we could request her.
All right, if you request her for tomorrow. And Norma, she is on page 1. Wait a minute, is tomorrow,
Trial docket?
okay. All right, and then Oscar Jimenez.
The box?
And this is the case, Norma, where the attorney said he was not. And you're Oscar Jimenez? Okay. So Robert, do you want Mr. Jimenez just to be recalled on a different day? Yes. Do you want it recalled next week or this week? Next week?
If we do it later in the week, we do it this week, later in the week.
Well, I mean, what is best for you? Do you want it later in the week?
Yes,
Oh.
I'd rather do it later in the week.
All right, Deputy Laura, on Oscar Jimenez, he's going to come back on Thursday, the 27th. And Bashan, on the last case we have, there's no application. It's a plea though. All right, are you ready for Mr. Jimenez to go back?
Yes, sir.
All right, Deputy Laura, you all can take Mr. Jimenez back. Yes.
No. I think I really think my. You know where the red button is at?
Yes, I do, and I have pressed it before without hesitation. Deputy Laura, there will not be any wrestling here in this court. All right, the court is calling 2024 CR 0331 State versus Richard Vance. Can I have parties approach and announce?
Rick Pena for the state of Texas. Well, report from Mr. Vance.
And are you Mr. Vance? Are you Mr. Vance?
Yes, ma'am.
All right, counsel, have you received all discovery? Did you review it with your client?
I have you.
Court will find that the state is in compliance with discovery. Mr. Vance, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we will waive the enhancement paragraph. No objection.
All right, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with failure to register with the previous. What is this previous IAT?
It's essentially repeated violation of sex offender registration. This isn't his first charge for this.
Okay.
Also, Judge, it's a 90-day, every 90-day registration.
Okay. That is a second-degree felony. Range of punishment is anywhere from 2 to 20 years with a possible fine up to $10,000. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you understand?
Yes,
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Vance, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
absolutely not, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am, absolutely.
Are you a U.S. citizen? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine. The state will take in consideration 2025 PF 07676, and there's to be Chapter 62 registration. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
It is, Your Honor.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State,
I'm
I'm sorry,
No contest.
no contest?
Apologize.
No problem. So let's make sure.
I'm just a
So-
little nervous.
Oh, that's fine. I understand. So are you pleading guilty, not guilty, or no contest?
Guilty.
No contest, Your Honor.
No contest.
All right, so let's try it again, because I want to make sure there's no need to be nervous. So are you pleading guilty, not guilty, or no contest?
No contest.
All right, and defense, it's your belief that your client is entering the plea no contest because you all have discussed his plea?
Yes,
And you believe the no contest plea is his intention?
it is.
All right, state any evidence.
Yes, Your Honor. This time state offers into evidence states exhibit 1 with all attachments.
No objection.
All right, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Respectfully, the court followed the agreement.
All right, the court will follow your agreement, sentence you to 4 years in the prison. There's a $1,500 fine, time and money to run concurrent. Take in consideration 2025 PF 07676, and there's to be Chapter 62 registration. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am, I do.
All right, here's the thing. We can go off the record. Here's the thing. Sometimes people have to register and they say, you know what, I shouldn't have been convicted of that case anyway, or I had a bad attorney, or whatever it may be. But that ship has sailed. You have to report, and you have to report every 90 days. And if you don't, you know what's going to end up happening? You're going to pick up new cases, and before you know it, you're going to be habitual, and your minimum is 25 years. So you better report.
I'll never be here again.
All right. Good luck to you.
Thank you, ma'am.
You're welcome. Well, we will be back tomorrow.